Thank you, Mr. Chairman, and I too want to congratulate Chris Russell on his 12 years. That's a long time to be serving here, and you have certainly helped the committee out greatly, and we appreciate your service as well, and we wish you very good luck in your next endeavor. I do want to just comment just briefly on subpoena power and about the SEC extending subpoena power to its employees. I just want to remind my friends, and you are my friends on the other side of the aisle, that this Congress, under the Republican House, has expanded subpoena power among, I mean, the gal that runs the elevator has subpoena power in this Congress. We have expanded the subpoena power for many, many chairmen that never had it before. So I am much more comfortable with the SEC having subpoena power and doing so in a deliberate and responsible manner than I am having it so widely dispersed here in the Congress. I do, Mr. Director Cerezny, I want to just mention one area where I think we can do much better at the SEC with the limited resources that you have, and that's the revolving door situation with SEC employees. We've had situations where I'm completely comfortable with folks at the SEC. They work, they learn the system, they understand, they have value in the knowledge that they gain because of their service at the SEC, and then at some point they make a lateral move. They go to the industry that can pay them much more money, and they have earned it. They have earned it. The same thing with our staff here. They toil here for a while. They do their sentence, and then hopefully they gain enough acumen and ability that someone seeks to hire them. This is a different situation that I'm addressing here. That is when SEC employees are involved in an enforcement action against a bank or a financial service company or any entity, and then while that enforcement action is ongoing, they leave and they go to work for the other side, for that company that has an enforcement or has a waiver pending. That cannot happen. That cannot happen. You can't have somebody working at the SEC prosecuting an enforcement case, and then all of a sudden the next week they go out and they're working for the company that they were just prosecuting last week. That cannot happen. So it does happen. It does happen. And so I recently introduced the SEC Revolving Door Restriction Act of 2015. This legislation will reduce the conflicts of interest beyond the current ethics rules. Specifically, this bill amends the Security Exchange Act of 1934 to prevent former employees of the SEC from seeking employment with companies against which they have participated in enforcement actions in the preceding 18 months. Just gives them a little cooling off period. You can't go to work for somebody you just prosecuted or waived an enforcement action against within 18 months. That would hurt the credibility of the SEC and hurt the integrity of the process. If that employee wants to go to work for that person, we leave an option here. If they're low level, not very much involved, they can go and get an ethics opinion that says that going to work for that company does not present the appearance of impropriety or compromise the standing of the SEC or put any party in that enforcement action at a disadvantage or give them an advantage. I believe that these added measures will improve confidence in the agency's ability to investigate suspected wrongdoing and continue the SEC's recent efforts to strengthen the agency's enforcement actions. This SEC Revolving Door Restriction Act of 2015 is supported by the Project on Government Oversight, POGO, a nonpartisan independent watchdog, and POGO has detailed the dangers of the revolving door, blurring the lines between the SEC and the interests that it regulates in a 2013 report. Dangerous liaisons, revolving door at the SEC creates a risk of regulatory capture. So they lay out the cases, the individual cases where this has happened, very powerful, and I want to give credit to POGO, the Project on Government Oversight, for the work that they've done on this. They really were the catalyst for my legislation. The report highlights that some SEC alumni routinely help corporations try to influence the SEC rulemaking. They also help them counter the agency's investigations of suspected wrongdoing, and they often try to soften the blow that the SEC might otherwise deliver in enforcement actions. They also block shareholder proposals, and they also, in times, win exemptions from Federal law. So, as I said, if we are going to maintain the SEC's integrity and the integrity of this process, that cannot happen. I thank you, Mr. Chairman, and I yield back the balance of my time.